is Heather Hurlitwin, and joining me here today is Heather Douglas. Hi, Heather.
Hi.
In today's video, we're going to talk about the simplified procedure for matters at the Ontario Superior Court. So to recap, you can go to small claims court in Ontario for disputes of $35,000 and under, but if your matter is over $35,000, you have to go to the Superior Court. Now, for matters under $200,000, the plaintiff may choose a process called the simplified procedure, which, as the name suggests, is a simpler process. Now, Heather Douglas and I have actually created a video earlier introducing this procedure. So click on the little I button above to watch it if you have not already done so. But in this video, Heather's going to talk about the simplified procedure timeline. Heather?
Thank you for introducing me and the video. The simplified procedure, as mentioned, is for certain claims under $200,000. And the first step is the pleadings. That includes the statement of claim, the statement of defense, cross claims, third-party claims, and so forth. And that is the first part of the process. It gets it going. And the rest of the timelines are pretty much based on the pleadings. So once you have your pleadings, the first defense is very important. The Affidavit of Documents is supposed to be exchanged between the parties 10 days after the close of pleadings. We have a video on the close of pleadings where we define what that means. It essentially means when all the pleadings have been exchanged, or any parties who haven't have been noted in default. Then the other timelines that follow that are based on the first offense. Within that 180 days or after it's been met, you have to file your notice of readiness. From there, you are going to have a pretrial date. Then the next dates are determined from the pretrial date. 30 days before the pretrial, you're going to have your trial management plan. And then 5 days before the pretrial, or at the very least, so you can do it beyond 5 days, you have to file additional documents with the court. And that includes such things like your Affidavit of Documents and expert reports and your statement of issues. There's a whole list of documents that have to be filed. Then the last thing is that we skip to the trial date. 10 days before the trial record has to be served and filed.
So Heather, are there some resources that you can share with maybe flowcharts or something that you can share with people so that they can have access to learn about this a little bit more?
Yeah, so the one is a rule of civil procedure. Go to Rule 76. The other one is a link from the Attorney General, the Government of Ontario. They have a tip sheet on Rule 76. And it's important to follow these deadlines. The big difference between simplified procedure timelines and ordinary procedure is that in simplified procedure, you're having to have settlement discussions very early on, and you're having to set your matter down for trial with your notice of readiness very early on.
Now, these notices and other forms that you mentioned, are they on the court's website? Is that correct?
Yeah, the Ontario rules of civil procedure forms, and many of them are listed under Rule 76, but the Affidavit of Documents is around Rule 30, and then an Affidavit of Service as well that you're going to have to file with a lot of these documents is wouldn't be under like the Rule 76 forms, it'd be earlier on.
Okay, yeah, go ahead, Heather. The
first document I'm showing you is what I mentioned as the fact sheet for simplified procedure. And this is from the Ministry of the Attorney General, January 2021. That's the date that a lot of these new rules under the simplified procedure came about. Some like modifications were introduced. As mentioned, it's for $200,000 or under, but above $35,000. It doesn't apply to certain types of actions. And you will need to serve and file a Form 76A. If you realize like it's under the wrong procedure, like if you should have been ordinary, but did under simplified, or vice versa. It's also a good practice to file it once the pleadings are done in any event, just to confirm that it's under the simplified procedure.
Now you mentioned the word ordinary, I imagine. So the difference, the distinction is ordinary procedure versus simplified procedure. Those are the correct terminology, right? Yeah,
and ordinary is like the claims above 200, or maybe those are the claims that are in the exceptions.
Right.
Those would also fall under ordinary. Parties can elect, they can choose to use simplified procedure even if they're in the ordinary procedure. But I don't know if a lot of people will do that because it has its unique set of rules that can be onerous as well. So you can choose to follow it. So here it says, file your Form 14A, your claim. That's the first thing. And then the defenses come in. And this gives the timeline for when a defense must be filed in the court. So if it's served in Ontario, you have your Affidavit of Service, 20 days within it being served, you should file your defense. But then there's additional days for other exceptions. Will it be required to go to mediation? That depends on the jurisdiction you're in. So you have to have a settlement discussion, but a mediation is a special type of settlement discussion. It has a mediator involved. And those ones are only required for Toronto, Windsor, or Ottawa. So after the pleadings are filed, you're going to go to your Affidavit of Documents, and this form says it's Form 30A or Form 30B. Make sure to do your Schedule D that lists your witnesses. That's different than an ordinary procedure where you wouldn't list your witnesses.
Right.
And so you have to discuss settlement. And once you have your discussion for settlement, you file your notice of readiness. That notice of readiness sets the matter down for trial. And then you will get a pretrial date. You have to attend a pretrial. And then, as mentioned before the pretrial, there are certain special timelines that have to be met. So your 5 days before the pretrial and 30 days before the pretrial are very significant dates. And then once you have your trial date, 10 days at least before the trial, you have to serve and file your trial record. The trial record contains the pleadings and the matter, and it's what the judge has when they go into the trial. And now I'm going to switch to another document, but this one is a very helpful link.
Yeah, it is. Yeah, it's great. Also, for our viewers, I'm going to have the link to this document in the description below.
And this is just the rules of civil procedure. I have it at 76.
Right.
That's where you're going to get a lot of your information on how to run a simplified procedure matter.
Right.
And it will give you all your answers. It lists your exceptions. It tells you your timelines. It tells you what your obligations are. It's all in the rules of civil procedure. Now, the last thing I'm showing you is the rules of civil procedure forms. And as mentioned, under 76, 76A, B, C, and D, you have a lot of important forms that need to be filed with the court. And there's also some forms in simplified procedure that are higher up on the court form list, but these ones for sure, these 4 ones, you're going to have to do.
I'm just wondering, based on your experience, your practice experience, running a simplified procedure matter versus running an ordinary procedure. What are some of the things you like about simplified procedure, and what are some of the things that you find that you didn't quite like? Yeah.
What I like about simplified procedure is the cost consequences. So there's special rules with respect to costs if you lose. It kind of caps the risk, because a lot of times what happens in litigation is you might have one party that has huge deep pockets, and they can essentially just run up their legal bill over and over and over again and kind of drive you out of the litigation. And simplified procedure tempers that with some of their rules around costs. Something I don't like about it is that I think even though it's a streamlined process for a self-rep, I think it's hard to follow because it's not, the rules are not given in a way that's like user friendly. It's not like you're going through a computer program and it prompts you every to the next step. You have to like be really careful and read the rules really carefully. Like if it's not designed into the process in a user-friendly way to follow the rules.
Oh, wow. So, when I first learned about the simplified procedure, I thought, why wouldn't everyone want to use this? I mean, for matters under $200. Would a plaintiff ever feel, no, they don't want simplified procedure, they want to do the ordinary procedure?
Some people might want a jury notice, and the jury notice is pretty much not allowed under simplified procedure. Like they might want certain things that are only available in the ordinary procedure. But if your claim is genuinely worth less than $200,000, then everyone should be thinking really hard about why they're trying to get under ordinary procedure, because the court isn't going to look, is not likely to look favorably on a party who insists on ordinary procedure when it's from the outset obvious that it falls within simplified.
Right, I believe that there are cost consequences to that effect as well.
Yeah. There are, that's right. Exactly like, which I think indicates the court's preference that you select the correct forum.
That's great. Yeah, great to remind us, because I think people think about courts as, oh, this is the place to fight. But I think a lot of people maybe don't realize that judges are always very supportive of litigants settling their matters out of court or just streamlining the process and making sure that their lawsuits proceed as efficiently as possible. Well, thank you so much, Heather, for explaining that to us. And thank you everyone for watching. If you like this video, please consider liking, sharing, or subscribing to our channel if you've not already done so. We really appreciate your support. And also as a reminder, Litigation Help Now has its own shop. We have guides on how to fill out court forms, which comes with explanations and completed examples based on a very simple fact situation. So if you need help in filling out motion court forms, don't forget to check these out. The link to the shop is included in the description below. So, and also don't forget to check out our short little video by clicking on the little I button above as a little introduction to these guides. And thank you so much for watching again, and we'll see you at the next video. Bye.
Bye.